So with that, I want to go ahead and turn it over to Margot Tank and David Whitaker from Buckley Sandler, who will go ahead and get us started off this morning.
Sure. Good morning. Is that too loud or is that?
There we go. All right, we're live.
So we're going to set the table as the Module 1, 101. It's the basics, nuts and bolts of what we refer to as the e-commerce laws. To some of you, this may be old hat. For some of you, it may be new. We're going to try to go through at a pretty quick pace and leave some time for questions and have good engagement with you. So, the e-commerce laws. The Uniform Electronic Transactions Act is the state law solution. The federal law solution is the Electronic Signatures and Global and National Commerce Act, or e-sign. We're going to talk through all the provisions. It's important to really understand how these laws work, understand the definitions, understand the procedural requirements, so that when you are presenting and offering your products or building your software solutions, that you weave the law into and through the technology and at the right point in the transaction. So both the e-commerce laws, UEDA and e-sign, they act as overlay statutes. They authorize replacing writings with electronic records, and they authorize electronic signatures. So we're going to talk in detail about what that all means. They require affirmative opt-in, so this is a choice. You can't require parties, whether it be B2B or B2C transactions, parties need to agree to transact business electronically. There are some outliers to the state adoption of UEDA: New York, Illinois, and Washington State. However, all three states have their own electronic signature and records law. And we'll talk about what that means in a little bit, about whether they're preempted and some of the details with respect to that. California is a UEDA state, but it has over 70 exceptions. There are real estate exceptions, insurance exceptions, Retail Installment Sales Act exceptions, and they really mean that. So again, we'll talk about what that means with respect to preemption and how to interact if you're trying to do business in California. There are special statutes, David likes to call them special. 4A, 5, 8, and 9 of the Uniform Commercial Code are outside the scope of UEDA and e-sign, but what that means is that they have their own electronic provisions contained therein. So if you want to do a chattel paper transaction, for example, you would go to Article 9 and look at that. There are special regulators. So the SEC and the IRS have been, in some ways, the SEC has been ahead of the game and has had electronic media rules for a while. I'm not sure whether they fully recognize e-sign. I think they see it as a sort of standing side by side.
They've described it as cute but unnecessary. Yes,
cute but unnecessary.
Cute but unnecessary. They really kind of, wasn't that cute? Look, they finally caught up with us over at the SEC. It has nothing, of course, to do with us, and then of course there's the IRS, which is nothing has anything to do with the IRS except what the IRS wants to have to do with the IRS. Right,
but they are making a lot of progress, and we've had, as a trade association, some success enabling 4506T in the mortgage transaction to be signed electronically. So there's hope and a lot of folks that are engaged at the IRS.
Hope is the word, yeah, for those folks.
Okay, so there are some key definitions, and this is legal, this is 101, so bear with us, but it's important to sort of understand, again, the basics. So record means information that is inscribed on a tangible medium or stored in an electronic or other medium that is retrievable in perceivable form. So all writings are records, but not all records are writings. An electronic record is virtually any record stored that is not on paper. So the definition's important because you can have a piece of paper, wet signature, and then convert it, scan it, convert it, and it then becomes an electronic record. Once it's an electronic record, you're within the confines of e-sign and UITA, and you can use those rules to meet your writing or signing requirements. Electronic signature means it's has sort of three parts. Electronic sound symbol or process, part one, attached to or logically associated with the record and executed or adopted by the person with the intent to sign. So you have the method, the sound, the symbol, the process, the I agree button, the biometric, the PIN, password, really voice, any type of method that you can possibly think of, or a process, meaning that you can't get from here to there unless you go through a bunch of steps. All of that would be an electronic signature. You need to take that method or process and have it attached to or associated with the record that's being signed. And the signer has to express their intent, and that can be done in many ways. Usually with language that says, by clicking the I agree button, I understand that this is the same as if I was signing with a pen on paper. Not all those words, but essentially explaining intent and explaining what the action means. And we talk a lot about labeling buttons.
Yes.
So we're button labelers, right?
I'll tell you what, it's really kind of funny. People get us on the phone and they run us through. They say, okay, let us show you our new signature process. And one of the things we're constantly doing is saying, you need to relabel that button that just says continue, okay? So if you take anything away from this conference, buttons that are labeled continue do not sign things.
Right.
They don't sign things.
So
Take that away.
They're not expressing.
Write it down.
They're not expressing clearly enough intent. So
Yes.
I agree, I consent, not continue. What does continue mean? It means I want to continue on through the process.
That's right.
Okay.
And to preview, just very briefly, kind of do a quick commercial for the last session this afternoon. You get a chance to meet some of the people who were involved in creating these two definitions, which are two of the most carefully thought out and in some ways innovative definitions to be found in American jurisprudence, and particularly the electronic signature definition, which at the time it was done absolutely bucked the common understanding and convention concerning what an electronic signature could be. This was revolutionary when it was proposed, because it was not what the legal industry and what regulators thought an electronic signature should be. It was very carefully, the things you see here processed, logically associated, very carefully thought through. You get a chance to meet some of those folks this afternoon. Little commercial.
Yeah, that's great.
All right.
So as I mentioned, ink type names, biometric, digitized picture, something simple, something complex, and voice. Voice signatures are being utilized in the insurance industry in particular. I think a lot of the telephone sales. So you could provide disclosures that are required to be provided in writing, either electronically or advance on paper, and then call and follow up and get a voice signature. But then you would need to record and associate that signature with the records that you provided in advance. So you can have a hybrid transaction, for example.
Right. And, you got one more there. I thought we'd come.
No, we're good.
I'm jumping ahead.
So you can tell we're both excited about these topics. So procedural statutes, e-sign and UITA, and really this is the prongs of the statute. This is all they say. A record or signature may not be denied legal effect or enforceability solely because it's in electronic form. It could be denied for other reasons, capacity, minor, disabled, but not solely because it's in electronic form. If a law requires a record to be in writing, and in many financial services transactions, for example, you have writing requirements, an electronic record will satisfy that writing requirement in the underlying law. And we'll talk a little bit more about overlay and underlying law and what that means in a second, illustrated by a case. If a law requires a signature, an electronic signature satisfies the law. So you're going to continue to see federal and state laws say writing and signing. What you then do is you look to UITA and e-sign and say, okay, if I play by those rules, I can replace that signing and that writing requirement with an electronic record or signature.
And now we come to one of the favorite cases of mine, and I think of Margot's here in the massively small jurisprudence we have over 14 years on UETA and e-sign. Barwick v. Geico, Arkansas Supreme Court, a few years back. Geico issued an automobile policy to a nice young lady. Nice young lady in the process of applying for and signing up for her automobile insurance through the Geico website gets to the point where she is asked whether or not she wants a particular type of medical insurance. This is medical insurance. It's small coverage. It's like $5,000. But it's coverage if you're hit by an uninsured motorist, you have medical expenses. Your own policy will pay up to $5,000 for, like, say, your immediate medical expenses resulting from this accident with an uninsured motorist. But it costs something, and under Arkansas law, you can waive. You can say, no, I don't want that coverage. I don't want to pay for that coverage, $5,000, pish tush. Don't want to deal with that, and I don't have to pay the premium. But Arkansas law also said, the insurance law said, well, that waiver must be in a signed writing, must have a signed writing. Well, she's at the Geico website. They ask her if she wants to have that coverage. She says no. They say, fine, here's a waiver. Please sign it electronically. She signs electronically saying, I waive the coverage. Well, a little while thereafter, the nice young lady gets married to a nice young man named Barwick. Mr. Barwick is out with the motor vehicle one day when he is hit by, it's Arkansas, an uninsured motorist. So, boy, I hope there are no Arkansas residents in the room. Okay. I happen to know Mrs. Clinton is across town, so that's all right. She's on Kelly and Michael at the moment. The Barwicks, Mr. Barwick then wants to recover some injury that he had during that accident. And when Geico says, sorry, your wife signed the waiver, you don't have that coverage, he sues. Now, I got to admit to you, I have always wondered what was going on procedurally here, because we're talking about $5,000, and this went all the way to the Arkansas Supreme Court. Clearly, Mr. Barwick did not hire my law firm to chase this down and argue it for him. I'm not quite sure how this happened, that it get all the way to the Arkansas Supreme Court, but it did. So they get to the Arkansas Supreme Court, and they say, look, the insurance statute says that this is supposed to be done in writing, and it's supposed to be done with a signature, and it was done electronically. And from a public policy point of view, Arkansas Supreme Court, you should not allow UETA. This was part of the argument that was made at the Supreme Court. You should not allow the UETA to apply here because you should create a public policy exception. This is way too important for all this nonsense electronic garbage. You should have to do this on paper, and it should have to be a signed writing. The Arkansas Supreme Court came back and said, no, no, no. First of all, at the time this was done, the Arkansas UETA was in place. The Arkansas UETA is very clear that it applies to this kind of transaction, and it's very clear what it does. And the Arkansas State Legislature, having made that decision, we are not going to interfere with it. And therefore, because the UETA says that a electronic record may serve instead of a writing, and an electronic signature may serve instead of a handwritten signature, for those reasons, we find that the waiver is enforceable. And I'm sorry, Mr. Barwick, you are not going to get the $5,000 for your medical expenses. This basically is the only case we have that illustrates the basic premise of UETA, which is that, that this substitution is supposed to be permissible, and that the statute works as an overlay and essentially amends all other statutes in the state that address transactions that are covered by the UETA. Rules for playing nice in the sandbox. Because one of the questions we get all the time is, okay, now we've got this e-sign thing at the federal level, and we've got the UETA at the state level. How do they work together? Or does e-sign just completely occupy the field? Is UETA now completely pointless? Which is what it was thought at one moment when e-sign was working its way through Congress might happen. All right? The order of events was that, and you'll hear more about this afternoon in the keynote session, the order of events was that UETA had been conceived of and drafted by the Uniform Law Commission, which has done many, over 240 Uniform laws have been proposed over the commission since its inception, which was in the mid-1800s. And the uniform, it's had several names. Today, the Uniform Law Commission. And in the course of that process, they developed the Uniform Electronic Transactions Act, and they started to get it adopted by the states. But the problem is it didn't really do anything for federal law, right? You can't have a state UETA affecting the Truth in Lending Act, federal statute. So the work starts to have this essentially nationalized, made federal through e-sign. Margot and Jerry Buckley from Buckley Sandler were absolutely central to that effort. And in that process, when it became apparent that e-sign could essentially completely preempt the UETA, while at the same time the people who were drafting e-sign in Congress recognized that they could not improve on what was in the UETA in most instances. They were going to borrow it. That then caused the Uniform Law Commission to get very distressed. And you have to bear in mind, the Uniform Law Commission is composed of politically connected lawyers and judges and professors who have been appointed by their governors. They usually are very good friends with the senators and the congressmen in Washington, okay, for their states, and they were unhappy. And so a compromise was developed in which e-sign has a very unusual reverse preemption provision. Basically, e-sign starts by invoking the full breadth of the Commerce Clause in the U.S. Constitution. Anything that Congress can affect in the way of a commercial or consumer transaction through e-sign, it proposes to do so. But states may supersede the requirements of Section 101 of e-sign, which is basically the UETA, by adopting the official text of the UETA before or after the e-sign enactment. Now you might ask yourself, good heavens, why would a state, since e-sign's there, why would a state want to adopt its own UETA once e-sign is in place? And the simple fact of the matter is most UETA adoptions occurred after e-sign was actually passed and signed by President Clinton. Why? Because it really chapped state judges to think that every time they were presented with an electronic contract, they were going to have to talk about federal law rather than the law of their state. And it chapped state legislatures. So what did they do? They end up adopting UETA, but in order to comply with e-sign's consistency requirement, they make sure that they're adopting a relatively pristine form of the UETA. Because in order to not be preempted by Section 101 of e-sign, you must either adopt the official text of the UETA or another set of rules, like they have in New York or Illinois, that are consistent with e-sign, do not favor a specific technology. If they're enacted afterwards, make reference to the e-sign Act. Note that consistent is not defined in e-sign, but it is defined in Black's Law Dictionary. Having agreement with itself, congruous, compatible, compliable, not contradictory. You have to, when trying to decide what that means then in e-sign, you have to bear in mind that e-sign is an enabling statute. It is not a prohibitory statute, it's an enabling statute. That means that anything that limits or attempts to undo what e-sign does would by definition be inconsistent because it is attempting to undo the enablement that occurs under e-sign. So, there are a few things states can do without having to pay attention to e-sign. Filing of records with government agencies themselves. This was a huge deal while UETA was being drafted. You had all these government agents coming in and going, oh my God, people will show up with a compact disc down at the Public Records Office and say, here's the deed you have to record. And so an exception was put into UETA. Also occurs in e-sign. It says, no, 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 if people are coming down to file records with you, you get to decide what form they have to be filed in, including paper. You can require paper.
Provides authority.
Authority. Don't have to, but can. Also, there are no rules in e-sign for something that is covered in some detail in UETA. When things are sent and when things are received. Very odd omission in e-sign. Do you know why that was omitted? I've never known for sure why that was omitted from e-sign. Didn't get there. We don't know why. But that means there are some delivery rules in the UETA that you either have to take account of, or most of them can be varied by agreement, so that you can vary those by agreement without being inconsistent with e-sign because it's a subject e-sign doesn't really address. E-sign does prohibit state regulators from using non-electronic delivery requirements to try to circumvent e-sign's enabling provisions. That means that post e-sign, if you are a state regulator or a state legislature, there probably is a prohibition on putting a provision in a new, say, commercial or consumer statute that says, and all of these documents must be delivered by hand, or they must all be delivered by first-class mail certified, okay? There probably are prohibitions on doing that now under e-sign because unless you can show that there's a good material reason for doing it that has nothing to do with trying to circumvent e-sign's rules. Other thing to bear in mind, very important, this is something that a lot of folks miss. The reverse preemption provisions in e-sign only apply to Section 101, okay? That's the basic UETA provisions. They don't apply, for example, to Section 104, which limits the ability of regulators to try to regulate around e-sign in the UETA. And there is no reverse preemption for the rules in Section 201 of e-sign that apply to the use of electronic equivalents to promissory notes in connection with real estate secured transactions. That means, for all intents and purposes, e-sign and not UETA sets the basic transferable record rules for things like a residential mortgage transaction, because there's no reverse preemption to allow the UETA to operate in that case. Was I going to continue to talk about that, or were you? I've forgotten where we were.
Scope.
Scope.
Scope, I think applies to the use of electronic records and signatures in virtually every business-to-business and business-to-consumer transaction, unless it's specifically excluded. UETA applies to state laws. E-sign applies to federal laws. Sometimes they both are applicable in the transaction. I'll just give you an example. For a mortgage transaction, you have a federal Truth in Lending Act disclosure, so you would look to e-sign. You may also have various state disclosures related to the transaction. You would then look to UETA if it's not otherwise preempted. Parts of the UCC we mentioned before fill in for anything that is the articles that are excluded from e-sign. So as I mentioned before, you go to those articles to get the electronic provisions, with the exception of 2 and 2A, which are covered by e-sign. So residential and commercial real estate, consumer loans, people ask us all the time, like, oh, is this transaction covered, or is that transaction covered? And the answer is yes, almost every transaction is covered, but there's a few exceptions, but it's a very broad enabling statute. Sales and leasing of goods, insurance policies, most securities transactions, procurement contracts, promissory notes. What are some other ones that we get?
Well, the one we get all the time right now is retail, that you've already mentioned, retail installment sales contracts. We get that all the time, and that's really been fascinating for me because to begin with, Article 2 of the Uniform Commercial Code is not excluded from the UETA. So to begin with, it's very clear your basic sales contract law in all states, covered by UETA, covered by e-sign. E-sign does not exclude Article 2. So then you go to Article 9. Article 9 has its own explicit, which is the other piece of this, the security interest piece, and Article 2A on leasing also not excluded from UETA or e-sign. Article 9 has its own electronic record rules, so it's clear you can do retail installment sales contracts electronically under revised Article 9 of the Uniform Commercial Code. And yet, just 3 weeks ago, I was at a conference where I had several lawyers who represent equipment leasing companies come up to me and say, we're not going to do any of this until there are some court cases that say that you can have an electronic retail installment sales contract and that address these issues of the enforceability of an electronically executed security agreement. And I said to them at the time, I said, bear in mind we waited nearly 14 years for a case that just says, yeah, UETA works. I said, so if you're waiting for this, I said, you know, I figured I'd start planning my retirement party first, you know, and then maybe, you know, maybe your successor will have a chance to actually see that court case. It is kind of strange. A couple of things are kind of strange. One thing that's strange is after 14 years, we got this little handful.
Well, and we're doing this discussion, right? We're
Yeah.
still educating,
Yeah.
and because it's complex.
It's complex, but the other part of that is that there are a lot of people who will say to you, the fact that there are so few cases after 14 years is not because nobody's using it. In fact, I worked for, this is no secret, I worked for Wells Fargo. I believe there are people from Wells Fargo in the room that I haven't had a chance to make fun of yet, and I will later, and they'll get a chance to make fun of me too. And I got lots of friends at Wells, and Wells Fargo was literally, while I was there, doing hundreds of thousands of transactions a day that were dependent upon electronic contracting. A day, hundreds of thousands a day that were dependent on electronic contracting. So there are, and that's just one company. So there is lots of use going on out there. There's lots of reliance going on. What's happening, we're finding, is that it's, when people do raise these electronic records and signatures issues, they are not getting past the district court level. Things like Barwick are really unusual, because when somebody does raise this issue, they get whomped down at the district court. The district court says, no, we've got this thing called a UETA. It's very clear you can do this electronically. It's not an issue. You'll also see that in a lot of cases that do actually get reported, that doesn't even get talked about. When you are talking about electronic contracting, everybody, the defense, the plaintiff, and the court just blows right past the fact that the thing was done electronically. The argument that many of us would make is that this is actually a testament to just how successful the statutes were and how clearly written they are. There's just not a lot to argue about. You really end up arguing around the edges. And particularly in consumer transactions, people hate to argue around the edges. They want to argue core principles, they want to argue core policy, they want to argue core fairness. So that you know, trying to argue, to me, one of the most fascinating things is after all this time, we don't have a single case on e-sign consent, which we're about to talk about in a few minutes. But I think that has to do with the fact that, number one, most of the time it's being done right, and number two, that because it's a fringe issue, it's just not attractive as a thing to have an argument about. So I find it to circle back around to where I started, one of my favorite things to do. I always come back around eventually. The fact of the matter is that it's very frustrating for me to go to things like this conference I was at and have these lawyers who are very well steeped in the areas of law they practice in be essentially expressing this kind of irrational fear of something that's so well established. Just because they haven't had a dozen judges say, oh yeah, this really works. Because it is working. It's working every day. It's working down at the courthouse. It's working in business. And it seems to me that there's a kind of reluctance still out there to believe it that after 14 years I find a little odd. Enough on that subject. What to stay away from? Because there are some things not to try to do with UETA and e-sign. Right? I like to say, watch out for bad things are going to happen notices. A lot of bad things are going to happen notices are actually in one way or another excluded from e-sign, the UETA, or Article 9 of the Uniform Commercial Code. Revised Article 9 does have a number of exceptions in it for things that still have to be in writing. And a lot of them have to do with bad things are going to happen notices. So if you're about to tell somebody, hey, you haven't paid your premium, we're going to cancel your insurance policy, hey, we're about to repossess your motor vehicle, you want to take a very close look. It's not that all of them are prohibited by e-sign. It kind of depends on what kind of insurance it is or what kind of circumstances it is with respect to the repossession of the motor vehicle. But you want to look at those very carefully and make sure you're not about to cause yourself a problem.
Yeah, and look at e-sign because it does specify and UETA what those bad things are.
Yes.
Okay, but then there's a judgment call, which is other things that aren't specified or aren't expressed, you may want to consider not providing electronically.
Or thinking
now, that
very
being said, it's not that you can't
Right.
provide them electronically. You're just not going to get the benefit of e-sign and UITA.
Right.
We
And
should talk about that a little bit.
Yeah,
because-
really. You sometimes just because e-sign and UETA don't cover it doesn't mean
that you
it can't be
do
done
it electronically. And then it's a judgment call, and
Right.
it's a consumer.
Right. And it was sometimes the
CFPB
statute actually
issue.
will say, oh, by the way, this can be done in writing or electronically. The regulation says that completely outside of e-sign and UETA. That does happen. They say that.
Yeah.
So in the same category are bad things have happened notices. We've canceled your insurance. We are denying your request for credit. Actually, adverse action notices, it's very clear, adverse action notice can be delivered electronically, but you do want to make sure that you've actually delivered it. One of the things that can become a challenge under e-sign and UETA is addressing regulatory concerns about errant email. Right? We have seen this. We have seen regulators who have said, look, we get that technically this can be done electronically, but how are you making sure it's been received? Are you getting an acknowledgement? Because they don't really trust email.
And the mailbox rule isn't established yet.
Right.
There's cases on it that support electronic delivery, like a paper envelope, you put a stamp on it, put it in the mail, it goes to the post office, you can deem it to be delivered. Some statutes say 3 days, but there's a mailbox rule. There's no mailbox rule under e-sign or UITA. There's cases that are starting to establish that, but there's concern by some regulators that delivery has not been met.
Right. There's some unhappy and happy family stuff that's expressly excluded, particularly from e-sign, and a number of states have picked up, incidentally, these exclusions. So it's not only an e-sign, there are UETAs that have also picked up these exclusions. So watch out for divorce, anything having to do with death, probate, estates, adoption, testamentary trust. Those are all areas to be very, very careful in. And finally, hazardous waste. I'm not going to take the time to tell that story this morning because we have to get to consent, and I don't want to do that. So we're going to talk now about actually getting into
Sure.
this stuff.
So, as I mentioned before, both statutes, e-sign and UITA, are opt-in. The premise was that the consumer, in most instances, had a right to paper, but also for business transactions, it's an opt-in. So for business-to-business transactions, any old agreement to use electronic records and signatures, either express or implied. You've been communicating by email with your business partner, and you can presume that they want to continue to communicate by email. That would be implied. Express would be you say, do you want to transact business electronically? Check the box. Pretty simple, express or implied. For consumer transactions, where the consumer is entitled to receive information in writing, okay, that right to paper under underlying law, under e-sign, and in 17 states, there are some very, very specific provisions with respect to obtaining the customer or consumer opt-in. So the consumer needs to affirmatively consent. Implied is not going to work. There are very specific disclosures that need to be provided prior to providing the information that you're intending to provide in writing. You need to provide what we call the consumer consent disclosures, which include what's the scope of the transaction, the ability for the customer to withdraw consent. If they withdraw consent, what are the consequences for withdrawing consent? Are you going to change fees or charge for paper? They're very specific, very express, pulled into 17 UITA states. And I guess the real bugaboo, which we struggle with, is the consent must reasonably demonstrate the ability to receive the documents. Reasonably demonstrate, what does that mean and why is it there? So the concern was when e-sign was being debated 14 plus years ago, was that there was a digital divide and that consumers wouldn't understand how to do an electronic transaction. They may not have the form or format that you as provider of the record would be providing it in. So, for example, PDF, Adobe PDF, it was sort of the beginning of time. You had to download it, it wasn't ubiquitous, and the concern was that you would provide, as a provider, the information in Word, or maybe we even go back further. So WordPerfect in Word, those weren't compatible. And so the concern was that you'd provide it in a form that the consumer couldn't open and couldn't read, and they would get, gobbledygook.
Yeah, it was quite seriously, incidentally, argued at the time the Congress was looking at e-sign that banks in particular, evil banks, would come up with new, obscure, I'm serious, new, obscure formats that no one could open or no one would know how to get a reader for, and that they would use those if they were not prohibited by this contract. It was, they were going to figure out how to make sure that you couldn't look at the documents they provided to you.
So the consumer consent must be electronic or confirmed electronically, and that was another consumer protection. They were worried that if you didn't do it electronically, then maybe you didn't have access to a computer. You could do it on paper, but you would then have to come back and confirm it electronically, and that really messes up a lot of different timing requirements. So reasonable demonstration, what does that really mean? There's no regulatory guidance on that. There are no cases on it. All we have is legislative history. And we've been talking about this legislative history for 14 years. One senator said, well, it's a self-reporting. If the customer says, if you tell the customer that they need this specific hardware and software to open and read and retain the disclosure, and they say, yep, I've got it, that's sufficient. We call that self-reporting. Another senator says, no, it has to be a test. There has to be some sort of back and forth to prove that the customer can actually open, save, read, retain the information. So as we go and advise companies, there's essentially a spectrum of risk we talk about. Depending on the type of transaction, if it's low level, you might want to engage in self-reporting, and if it's something more risky, you may want to do more. What's the more? The more can be a test PDF where you send it in PDF, the customer has to open, gets a code, kind of like a CAPTCHA, puts it into a field in the computer. There's lots of different ways. There's not many that are doing that. Most are relying on self-reporting, but it's still out there and hasn't been tested yet. So where we see the most problem is when you have in-person transactions. So you come into an institution and you're on the provider's device, whether it's iPad, let's say, and you sign electronically. And it's pretty easy to prove that they're there, you authenticate them, they walk through the process, they sign, they consent, yes, I want to do this electronically, but you have a requirement to provide the information in writing in a form that they can keep. If you don't print it out and they don't walk out of the institution with it, they say, then you'll have to send it to them. Well, does that really reasonably demonstrate that they can retain the information? So they're gonna say, yes, I have an email address. But what if they don't really have an email address? What if they make up the email address? What if they send it to some errant, it doesn't bounce back, but it's sent to an email address? You may not have met your delivery requirements. We tend to worry, and we talk about all the worries and all the risks, but there are a lot of companies, and many are doing all of this. And as time goes by, people are doing business, it becomes commercially reasonable, there's expectations of delivery, that mailbox rule will just happen by matter of course. So we don't want to be too negative, but we want to sort of caution.
Yeah, no, I think it's fair to say. In fact, the mailbox room is. I was actually kind of surprised. I had really thought there, up until a couple of years ago, that there really weren't many cases or much guidance with respect to the use of email and reasonable demonstration. And then Margot did one of the things that partners at law firms are really good about doing. She looked at an associate and said, "Go find out if that's actually true." And the associate, a wonderful guy, goes forth and he pokes around and he comes back and he says, "David, you're full of it." I said, "I knew that, but what are we talking about specifically?" And he said, "No, it's the whole email thing." He said, "There's actually a lot of cases out there that will indicate that you're entitled to a presumption that email is delivered unless there's some actual proof or evidence to suggest that it didn't." I was like, "Oh, wow." So lo and behold, there actually is a fair amount of precedent on that subject. What I think we still worry about is the case when you know it didn't get there.
Right.
That's
right.
the one we worry
so
about.
the bounce back. If you
Yeah.
know that it was not delivered, you're going to have a duty and obligation to redeliver it.
Yep.
You're not going to get the benefit of UETA. E-Sign doesn't address that, but you're on notice that it wasn't delivered, and that's also tricky. Do you send paper? Do you send it again by email? Do you call the customer? So you want to have bounce back procedures. I guess just to wrap up on consent, and then we're going to kind of pick up the pace here.
Pick up the pace, yes.
Is aside from delivery, really think about, you want to make sure that the scope of the consent is clear. So what are you delivering electronically? Again, I'm just going to keep using a mortgage transaction as an example, but are you delivering just the initial disclosures, or are you post-closing, later servicing disclosures? You need to be very specific and very clear with the scope. You also need to state, because e-Sign says so, that the customer has a right to paper. We're hearing from the regulators they want to actually see those words in the consumer consent. Customer, you have a right to paper, and you are choosing to do this electronically. So right to paper and scope, and if there are consequences for withdrawing consent, really need to specify what those are.
Yes.
Keep moving on.
Onward and
We've
upward.
got 5 minutes
I got
and
5
37
minutes, so I'm
seconds.
going to walk through attribution. All right. How does this always happen to us? I don't even want to. We keep shrinking down what we're going to try to talk about in any one 45-minute session. It doesn't help. Legal sufficiency versus attribution. UETA and e-Sign only answer the question, is it a signature? They do not answer the question, is it your signature? So you have to prove attribution. It can be proven basically by any means, including circumstantial evidence, and the burden of proof is on the person seeking to enforce the signature in most states under U.S. law. Okay? There are some exceptions, weirdly enough, but for the most part, it is the burden of the person who is seeking to enforce the signature. You must also establish authority to a certain extent, in that people need, of course, to have the authority to sign in the capacity they are signing, whether it be individual or as a representative for an entity. And then intent has to be established as well. Watch out for placement of calls to action, signature calls to action, the buttons we were talking about. We spend a lot of time when we're looking at implementations, both looking at what the buttons say or what the language around the buttons say, but also where they're placed, because there are courts that have made a point at this juncture of saying, we expect the call to action to be below or to the right of the information that's being presented for agreement. If it's above or it's to the left, we're going to have more of an issue because of how people read.
And if it's gray, they might not be
Yeah.
able to see it, so you might want to make it green.
Yes. The other thing we get questions about all the time is everybody thinks it's a wonderful idea to have a consumer be presented for 5 documents and then be presented with one button that says, I'm signing everything. Watch out for that. First of all, there's a question about whether or not you've established intent for each signature, and the other thing to bear in mind is there are a lot of state laws that say, and the following notice must appear above the signature line, right? If you don't require the consumer to actually visit that signature line, they may not see that disclosure, and you could have a judge decide, well, basically you defeated the entire purpose of the state law requiring the placement of that notice. You might be able to do something innovative in order to present it without it being above the signature. But you want to bear in mind that there's a reason why those state laws say, and this has to be placed here. So watch out for multi-signing, particularly in consumer transactions, not so much in commercial, where everybody's supposed to be able to look out for themselves. One of the ways that frequently you, of course, establish attribution is by establishing a credential. And we're going to talk more about that actually tomorrow afternoon. But a credential is often used, it's first established, essentially you have 2 identity events in many transactions. The first one is, to what extent do we need to know that Fred is Fred? And then secondly, and that's frequently when you get things like knowledge-based authentication, shared secrets, things like that. Then a credential is established, user ID, password, biometrics, whatever.
Me too.
And from there on, the question is not still is Fred Fred, but is the same person we were
found
dealing
mine.
with before that we thought was Fred, the person we're dealing with now. And that's where the credential comes in and becomes very useful for attribution. You've completed your initial authentication process, whatever it is, big, little, extensive, not extensive, but you finished it. Now you've got a way for somebody to come back over and over again and interact with you without having to go through whatever that level of authentication is again. And it can be tied to signature. Finally, authority. What we are learning as we practice in this area is that for the most part, electronic signatures and records just really don't change the authority profile much or how you go about getting it. An awful lot of companies that we deal with are moving to electronic records, electronic signatures, but not really changing the process by which they establish authority to sign, especially for representatives of legal entities. We basically see 4 strategies, and they all predate electronic records and signatures. The Hail Mary, very popular. He says he's the vice president for technology, we're going to go with that. Very popular with business. Certificates of authority, very popular with banks. Secretary of the company says, yes, he's really entitled to sign all his stuff. Situational, actual or apparent authority. Well, we know he's the chief financial officer. We're not going to bother with a certificate. We're going to assume he can sign loan agreements because he's the executive vice president for finance. We're not going to go through a formal authority process, but his circumstances and his title give us comfort. And then finally, a hierarchical model. This actually first appeared with respect to wire transfer, pre-e-sign, to my knowledge. That was how it first showed up. And the idea is that you give somebody a master password and credential, and then they assign credentials with authority to people underneath them. And they are responsible for all those sub-assignments. So there's kind of the basics on authority, attribution, and intent when you're working with electronic signatures, and I think that leaves us with a few minutes for questions, unless you want to
I just want to
wrap up.
mention
I
SPURS,
beg your
which
pardon.
we're going to
Go
talk
ahead.
about tomorrow. Standards and procedures for electronic records and signatures will sort of hold on what that is. But just to mention that all the cases that we've been talking about, mailbox and attribution authority, any case on consent, we've cataloged in SPURS. So there's an appendix, and we've tried to put together most of the significant key cases that we've found over the years, regardless of the vertical. So it's all in SPURS, and we'll talk more about that tomorrow.
No. And we do have a couple minutes, well, sort of, for questions. We have stunned you into silence. Yes, ma'am. Ask us again. Speak up a little and ask us again.
Are any of the business to business?
The question is, to what extent are the statutory provisions variable by contract? This is perhaps one of the biggest reasons why the adoption of UETA under state law is important, because a great many of the provisions in the UETA are variable by agreement. You can, for example, sending, receipt, use of electronic agents, those are all variable by agreement under UETA. E-sign, of course, is a federal law and does not say anything about variation of its terms by agreement, so it is not, where it does not say so. UETA generally is variable by agreement, particularly with things like another area where there's a lot of this goes on is record retention. What will constitute the place where the records will be retained for the parties? Things like that you can make agreement on. Other questions? Oh, let's let Jeff get the microphone up to you.
Thanks. Would insurance company delivering documents to an agent for ultimate delivery to the insured be business to business or business to consumer?
Business to business.
That would be business to business. And also bear in mind, that's done, one of the things that's interesting about that is unless those documents are being delivered for effect to the agent under a law that requires a writing, I think that's done very frequently today. My father was an insurance agent for 53 years, and by the end of his time in the business, he was getting nothing on paper anymore from the insurance companies he worked with. It was all electronic. He printed out a lot of it then to deliver to people, right? So you both have the fact it's business to business, and you have the fact that in a lot of cases, since it's not being delivered for effect, it doesn't matter that it's being delivered electronically. It's going to be delivered for effect when it gets to the customer.
And what you would need to think about in that scenario, because we've been asked these questions before, is the consent. Does the consent come from, do you get the consent from the insurance company and or the agent? I mean, it really just depends on the relationship, and we'd say both, but that will come up.
Yep. Other questions? One over here.
Sorry, we're all looking this way.
Yeah.
That's okay.
Yeah.
Okay, there it is. Yeah. I'd like to hear a little bit about the interaction these days between the American Disabilities Act and eSign and UITA. They came, they saw, they clicked. You know, how are those things getting talked about?
Oh, that is a great question. That could be
Right.
actually a session of its own. We do work with that quite a bit, and in fact, we recently wrote an article that got
Right.
published someplace on ADA on this. First of all,
It applies.
one of the really important things to do
It's the
is
answer.
to look at W3C. All right, the Worldwide Web Consortium has produced outstanding guidelines for interactions. Second thing to bear in mind is Android and iOS both have excellent and constantly growing features, and what we tell people is you have to design your system to the fullest extent possible and is allowed under the W3, because W3C recognizes exceptions where things don't work right and they know it won't work right. But you have to look at those when you're designing. And in fact, I have told people very directly, if your designer looks at you when you're talking to them about designing an app or designing a web page for you and says, what the hell's the W3C, or what do you mean the ADA tools in iOS or Android, you got the wrong designer.
Right.
Okay, they're not the right people.
Is there any case activity yet?
No. The closest you could get are the ATM cases. Look at the ATM cases. Those are going to be the best, I think.
Yeah. Margot and David, thank you. I think we're going to go ahead and wrap it up for now, but we'll have you back here in about
Thanks.
a little bit.